Are you videotaping us too?
We are, and I just hit start.
Okay. All right. So we are recording. Good morning, everybody. Welcome to the June 5th CBLS meeting, our open session. The first thing we will do is have, I'll call this meeting to order, and we'll have Adrian call the roll.
Sure. Acosta? Hammerschmidt? I think I see him on the list, but we'll wait and see. Hershenson? Oh, sorry.
You got him muted.
I apologize, folks. I could have sworn that you had the ability to toggle it yourself. It looks like if you toggle yourself off, I might have
You're
to.
automatically off? Okay.
Yeah.
I'll leave it on. I'm here.
And Natalie's on mute too.
All right. You know what? I'm going to upgrade everyone else just to one more thing. So you should. I'm going to upgrade everyone else one real fast, and then I'm going to recall roll.
Okay.
Let's see this. Sorry. Is that everyone? And then if you're State Bar staff, if you want to just send me a message privately if you want me to make you a co-host or to unmute you again. Cool. I think I grabbed everyone. I'm going to recall roll again. Acosta? Hammerschmidt? Hershenson?
Here.
Lester?
Here.
Levy?
Here.
Torre?
Here.
Advance.
She's muted.
Muted.
But
Oh, did I miss that one? I'm so sorry, Natalie.
she's definitely here.
I got you, Natalie.
She
I'm
is.
here.
There we go.
Perfect. We have enough members for quorum. Thank you, everyone.
Outstanding. All right, thank you. Okay, from there, we will go to our call for public comment. And we have, I take it, so but before we do this, because we have these protocols, these new kind of how public comment is taken with these Zoom meetings. Should I, would it be best to just first see if there is any member of the public that would like to comment, or should I just go through these procedures before we do that?
There's only one other person. I guess it's up to you.
Right. Okay. Well, I'll just go over this. It won't take forever. Okay. We are taking public comment in this open session, as we typically do. For those of you members of the public who are participating via Zoom, you have a function for virtually raising your hand within the application. If you're virtually participating by phone, you can virtually raise your hand by pressing *9. That's a star key, then the number 9. And doing so will alert staff that you'd like to make a comment. Staff will call members of the public in the order that their virtual hands are raised. And we will please ask everybody to limit their comments to about 3 minutes. You'll be notified when you have 30 seconds left to conclude those comments. And at 3 minutes, your microphone will be turned off and the next member of the public will be called. So with that, are there any members of the public who would wish to comment using that function? And I believe we have a chat greeting. Does anybody, would anybody like to make a public comment at this time using those procedures? Hearing none. Okay, well, we will go on to the next portion of our open session, which is the staff reports. And with that, I would turn to, do we have Audrey on the meeting? Here we go. Yes, yes, there. I was just counting my
I
boxes.
just had my video off for a second.
Okay, no
I'm-
problem. I was just counting our Brady Bunch like boxes here and stuff. I didn't see you. There you are. And I believe you called in. You called in at the last meeting. So just to reintroduce you to everybody, Audrey, everybody, Audrey.
Hi. Yes. The last meeting was right after I started as assistant director for admission. So now we've had these interesting few months in the interim between meetings. Nice to
Right.
see you. So just a few staffing updates. We have, I think she's on the line, but we have a new staff person who's on a T&D, which is a training and development program that we have at the State Bar. Patty Salazar joined the team the last couple weeks. Adrian, who you all know well, is actually on a training and development plan as well to be the supervisor of the program. And our open position that we've had for a while for program specialist, we actually have that filled. We have someone who's accepted the offer and will be starting in 10 days. So you'll see a new face the next time we have a meeting like this.
Okay. All right. Well, thank you. Welcome aboard. And thanks again for that update. And with that, we'll turn to the CBLS, the 2020 work plan initiatives. And for that, we go to Adrian.
Sure. I apologize. I'm pulling it up, switching the screens right now. Oops. I'm going to, where are you?
Adrian, were you going to post something for us?
Yeah, no, I'm so sorry. I'm trying to switch screens to show it.
Yeah, gotcha.
Yeah. Share screen.
Oh, there we go.
All
Does
right.
everybody have the PowerPoint up?
Yes, I do.
Cool. So for the 2020 CBLS work plan initiatives, this was approved by the, excuse me, it was approved by the Board of Trustees earlier this year. And we have some updates regarding the 3 out of the 4 initiatives. I apologize. I keep having to switch screens. This is the one I want.
I think we lost the PowerPoint.
Yeah, sorry. This is the one.
Back.
So this is the work plan that was approved. Regarding the first initiative, create legal specialization working groups. We have recruited from past advisory commissioners, graders, and current specialists, and as well as new specialists. We have working group members in the specialty areas for appellate, bankruptcy, criminal, estate, family, immigration, taxation, and workers' comp. For the next initiative, guidelines for evaluating proposals for expanding certification areas. At the last CBLS meeting, the CBLS approved an amendment to the standards for determining the creation of a new specialty. And a couple of organizations have also since requested and received those updated standards. Regarding the third initiative, evaluate psychometrician's findings for grading study. The psychometrician provided his final report in May, and then this will be provided in September for review and discussion. For the last initiative, create procedure to ensure attorneys do not misrepresent themselves as specialists. Staff, we're continuing to consider these procedures, and we're hoping to have the provide a preliminary process to the CBLS, hopefully for its next meeting in September.
Okay. Okay, that's it. And so we of the specialty areas, so we're missing any for the work groups. We have nobody for admiralty, nobody for legal
Franchise.
practice, and then only one for appellate and estate. So but in general, we're coming along. It seems like roughly we've recruited about half the people that we need.
I would say so. Ideally, we would like to have 5 for each specialty area. We have not yet met 5 for each of those specialty areas. But staff continues to recruit, and we're considering new options to reach out to those specialists.
Okay. Okay. All right. Well, thank you, Adrian. All right. With that, the next item on the agenda is for recent developments, and for that we turn to Amy and Audrey.
All right. Well, welcome everyone. So I want to give you an update on State Bar operations as a result of COVID-19. Clearly, we've all been affected by the COVID-19 epidemic. And as many of you have learned, the State Bar has been closed to the public since about early March. And what that meant is all units at the State Bar kept daily operations functioning, carrying out essential functions such as our correspondence and returning calls. And staff were allowed to telecommute full time for that. Unfortunately, between telecommuting, social distancing, and sheltering in place, it prohibited some tasks from getting accomplished, such as our conducting swearing-in ceremonies. We weren't able to do that for the February 2020 graduates. And so, and they were moved to virtual ceremonies. And this impacted units in a varying fashion. So even for us, as you may recall, the CBLS held their last meeting via Zoom related to this. So where we're at now is on June 15th, we are going to start a slow return back to the office. And the goals with that return are to ensure that all tasks are carried out. As I mentioned, there's some that we weren't able to fully continue. And also ensuring that safety concerns are addressed, which means that we're going to continue allowing telecommuting. That's been successful. For those that are coming in, we're trying to create staggering schedules to minimize employees congregating. We're implementing safeguards with social distancing and spacing within the office, mask wearing, and hand sanitizer accessibility. I do want to note that these events also allowed the State Bar to reevaluate processes that could have that could be impacted by the COVID-19 health measures. So in light of that, for example, the Office of Admissions granted applicants more time to provide fingerprints, transcripts, and certificates of good standing. Also, registered and accredited law schools were allowed to provide law courses online. And we continue to identify areas where there's some room to relax some of the strict timelines, given that many businesses and law schools and schools in general have experienced this impact. So we're encouraging all units to assess their processes with this in mind. So for example, specifically to the CBLS, you guys might want to consider whether there are areas that may impose undue hardship on applicants that could be relaxed. So just a thought there. Any questions related to State Bar activities around COVID-19?
I just had a comment. I think that what you said, we're basically going to have to put a pin in that And I think prospectively, and it's going to come up later in the meeting, I think, with a few things, but I think a lot of the deadlines we have and a lot of the expectations we have vis-a-vis how many people are going to apply by a certain date and stuff like that, that's all, I think, going to be blown up by current circumstances. And
Exactly.
I think that just like the bar is just, it's like trying to fix a plane while it's in midair, like it's very hard to do. And that's what I think we're also going to have to be doing vis-a-vis a lot of these like deadlines and stuff. So I think that,
Okay.
yes, thank you. Anything more in terms of recent developments?
Yeah, I wanted to update everybody on the June baby bar and the July baby bar. And I wanted to update everybody because some of the initiatives are currently scheduled and in place may have an impact on upcoming exams depending on how the epidemic persists or continues. And so in March, when the news of the COVID-19 outbreak started, the State Bar, the Supreme Court, and the Committee of Bar Examiners, and even law schools started engaging in investigating methods for licensing graduating law students and the impact that it would have on students that are taking these exams after their first time. And so a lot of options were considered, including a diploma privilege, provisional accreditation, switching the modality of the first year exam and the bar exam to an online format, and postponing all exams until next year. On April 10th, the Committee of Bar Examiners met and developed a set of recommendations that were submitted to the board. On April 15th, the board considered some of those recommendations and submitted a set to the Supreme Court. And on April 27th, the Supreme Court is the ultimate authority on the bar exam format and content and administration. And they sent a directive to the State Bar on how to proceed with these examinations. So just want to give you a heads up about what that directive is. These were the directives that were implemented. So the July 2020 bar exam has been postponed to September 9th and 10th with the goal of administering that exam as an online exam. The State Bar is set to work with the National Conference of Bar Examiners to facilitate an online administration of the MBE, that is the multi-state bar examination, the multiple choice portion of the exam. We're to allow applicants a flexibility for planning and preparing by allowing them to withdraw up to September 8th, the day before the exam. The State Bar is required to make every effort to provide a speedy delivery of the grades. So the deadline for results with the September deadline, with the September 9th, 10th administration is December 31st. We are to administer a June 2020 first year law student exam online while allowing the students the ability to qualify for law school credit for 4 times rather than 3. So some of the rules have been relaxed. Typically, law school students at a registered law school have to pass a bar exam within the first 3 attempts in order to get credit for their second year of law school. The Supreme Court has created flexibility and changed that to 4 times for this upcoming cohort of people who are eligible to take this exam. The June online exam is going to provide experience that will apply to the September 2020 bar exam. And the October 2020 first year exam has also been postponed to November. The State Bar was also required to submit a work plan that included milestones and beta testing dates on May 11th, and that has been completed. And lastly, the court's going to continue to explore alternatives and options as circumstances develop or change. And one of the latest developments is that the NCBE has been able to develop an alternative online version of the MBE for us. However, the administration for that date is only on October 6th. So the court is in receipt of that information, and should any plans change, we will be informing applicants and the general public about that. So it's been a very long process with a lot of involved stakeholders. We've taken hours of public comments on this, so we clearly have to keep the interest of public protection and consumer protection in this process. So that is the update on the both the June and the July, June baby bar and July bar exam.
And those, the security parameters for that are the same as I think we had talked about before, like the in terms of like being able to monitor the test takers, like
Yeah.
I mean, there are.
It's changed a bit, and it's probably not wise to talk about this in open session. However, let me just say this, that one thing is pretty clear, that you know, I think when we last spoke, the idea was that everybody needed Wi-Fi throughout the exam, and that was going to be one of the potential setbacks of using the system. The way the system's designed now, and since our last discussion, there's been some advancement in what that Wi-Fi capacity is. And so students or examinees will have to conduct a mock exam where they, a mock certification where they pretty much certify their laptop, take that baseline photo that will be used to establish their identity during the exam, and gets the system scheduled for the delivery of the actual exam. So on the day of the exam, students or examinees will need Wi-Fi for the facial, identification, verification process, for the delivery of the questions. But then that shuts down as they're taking the exam. So the Wi-Fi requirement is not as intensive as I think originally discussed. The other thing is that there are about 2 rounds of review that are going to be conducted. So the initial one is artificial intelligence that's happening behind the scenes, because the session is being recorded. And so behind the scenes, artificial intelligence will flag any of the erratic behavior that we've discussed, and anything that, for example, leaving the camera at any point during the exam administration will create a cheating flag. And what happens is our vendor is going to review those that footage and flag that for us, and then staff will make those determinations. And so there's pretty much 3 levels of review that are scheduled to occur. The first, artificial intelligence, then human, and then State Farm humans.
Okay, and by the way, yeah, I didn't want to suggest that I wanted to do a deep dive into very kind of secret sort of stuff. It's just to kind of just as a note, just because I think that's one of the first things that people think. They're like, wait, this stuff's going to be. But in general, there are these kind of measures like taking into account that people are going to be taking the exam remote.
Yes, and there are a lot of factors that we had to weigh out. For example, we have some people that traditionally are writers, and they're not going to be able to take the test online. So there's also testing accommodations that do not lend themselves well to an online exam, and those applicants have had options. They could withdraw or petition to us and take the exam in person. I'm so sorry, there's work happening next door. And
okay.
I'm sure you guys could hear that, right? I'm really sorry. But anyhow, so yeah, there's a variety of factors that we had to take into consideration. I mean, and at this moment too, we recognize that students are living in their parents' homes, and people are all sheltering together, and that private space may be very challenging.
Hard to come
So we are in the process of addressing those. We're trying to make sure that we're as inclusive as possible. For the baby bar, applicants will be taking the exam, the in-person folks are going to be taking the exam at either the LA office or in the San Francisco office. So we are providing those accommodations.
Okay. Thank you for that. I mean, and I think I would speak for everybody that like it's a bear to put together all these logistics during the best of times, and like keeping it going and like coming up with these like different these different parameters now is at least from what I've seen, but what you've said and stuff has been pretty impressive. So.
Yeah. Thank you. Yeah, we have a good team.
So, okay. Anything more on recent developments?
No, that's it.
Okay. Okay. All right. Well, with that, we're going to turn to the consent portion of the agenda. And the first part of that is going to be reviewing and approval of the March 13th minutes. It's one of the first things in your packet. In fact, I think it's like right after this agenda. It is the first thing in your packet. Does everybody have those with them, in front of them, accessible somewhere?
Yeah, and I looked at them earlier.
Yeah, I took a look. I didn't see anything to which I had vehement objection. I don't know about anybody else.
Same here, so I'm happy to move to approve those minutes.
Mark moves to approve the minutes. Do I have a second?
Second.
Second from Rob. All those in favor?
Aye.
Aye.
Adrian, are we gonna have to technically take like roll with these Zoom meetings, or can we just like by voice vote just do these?
To my knowledge, and we can ask our general counsel. He's on the call too, but it is roll call votes.
Oh, okay.
Ken, did you have something to say? Sorry, I think I saw you.
Yeah, hand raised. You may need to unmute him.
Okay.
Thanks, Adrian. Yeah, that's right. Everything has to be roll call. It might be a little
Okay.
monotonous, but it counts as if it's a telephone call. It has to all be roll call.
Okay.
Makes sense.
Cool. Hershenson,
Yes, aye.
Lester,
Aye.
Levy,
Same.
Torre,
Aye.
and Vance.
Aye.
Great, thank you.
All right, minutes approved. And with that, we would turn to the review of our latest report on the financial and operational key indicators. And with that, I believe we would turn to Audrey. Still muted. She's trying to get her way in. She's muted.
I got it, sorry.
Sorry.
There you go, Audrey.
Can you hear me now?
Yeah.
Can you hear me?
Yes.
Yeah, we can hear you. Nope. Now we can't hear you. Can't hear you. Still muted. She's still muted. There we go.
Did that work?
Oh, yes.
Am I okay?
Now we can hear you.
And
Oh my goodness.
hey, Audrey, if I can interrupt you just 1 second, there is somebody's camera that is showing down on papers. I don't know what the papers are, but it says Jeff. We should just let them know so they can. There you go. Sorry.
Okay, no, I didn't see that. Okay, thank you. Sorry for the glitch. So I'm going to go over sort of those high-level financial and operational key indicators that you all have in the materials for today. You have the Board of Trustees fourth quarter report on the financials. Included in there is the revenue and expenses for legal specialization. So by the end of 2019, we were down in revenue by 0.5%, but because we had fewer expenses, we actually ended 2019 with a net positive change of $969,284. So turning to the number of specialists, we are up on specialists from a year ago. That's through the first 4 months of the year, through the end of April. So we have 26 more specialists than a year ago. Estate planning, immigration, and workers' compensation was where we saw the largest increases. And then admiralty and family law, we lost 11 total in those specialty areas. You have an attachment about resignations. Again, the first 4 months of the year, we saw 88
now.
resignations. Hello?
Am I on mute?
Does someone have a question?
Can you hear me now?
Yes.
Yes, Jeff.
Yeah.
Sorry about that.
This is Jeff Hammerschmidt. I've been on since 10, but I haven't been able to be heard until I just got unmuted.
I'll note that, Jeff. I apologize.
And my votes are along with everybody else's so far.
Thanks, Jeff.
Sure.
Sorry about that, Jeff.
That's all right.
So we've had 88 resignations in the first 4 months of this year, but half of those are due to retirement. And we look to be forecasting the same total of resignations for this year as we did in 2019, which was 160, and 2018, which was right around that at 158. So turning to legal specialist CLE, you also have an attachment about legal specialist CLE. 1,949 specialists when reporting opened. Compliance reporting ended on February 1st, but if you recall in the minutes from the last meeting, we approved extensions through June 30th and to follow the CLE extensions that the bar is giving for general CLE. And since our last meeting, the State Bar approved extension of CLE reporting to September 30 because of COVID-19, similar to what we were talking about at the top of the meeting. So based on what we talked about last meeting, we will also extend the legal specialist CLE till September 30. And as of May 1st, 43% are still pending in terms of the reporting for their legal specialist CLE. And that's a quick overview of those key indicators.
Okay.
And Audrey, is following up, is your report including the results of the people that were scheduled to be terminated because they hadn't renewed in time or done their stuff?
In terms of their resignations?
Not the resignation, but we had at the last meeting, there was a list of some people whose certification was going to be pulled if they didn't respond or get corrected. Is that within this report?
No, so in terms of people who are, and Adrian can probably speak to the list of people who are waiting to recertify.
I think maybe.
If they don't, we will, go ahead.
Yeah, that's next. That's a couple.
Was that
items
next?
down.
Okay, got it.
Yeah, attachment 4C, or excuse me, item C.
You're just getting excited about what's coming up.
Look at that, exactly. You're out kicking your coverage. Mark.
Dang it.
Okay. All right. Are there any questions about those key indicator reports? Anybody? All right. Thank you. Thank you, Audrey. And from there, we would turn to review of the report on our initial certification applications. For that, we turn to Adrian.
Sure. So this item is an update on the status of eligible applicants who have submitted their post-exam application for initial certification. In order to receive certification, applicants must first take and pass the legal specialist exam. Then they are eligible to submit their post-exam application for initial certification. Attachment A will detail those who passed the 2017 examination. Those successful applicants, they have until January of next year to file their application. From that administration, there were 704 applicants that passed. To date, 74.7, roughly 75% have already filed their application. Of those remaining applicants, 22 have not yet received an extension through January. However, we still continue to reach out to those applicants, and should they request an extension or submit their application, we would still accept it. Attachment B that details the successful applicants of the 2019 legal specialist examination. Those applicants will have until April 2021 to submit their application, or they may request an extension of time through January of 2023. From that administration, there were 382 successful applicants. 17% have already filed their applications, and 2 have already received or have already requested and received extensions through January 2023. The most common reason for an extension is so that that applicant can reach that 5-year practice requirement in the specialty area.
So we're not contemplating at this point a blanket extension due to COVID-19, or we're still going to take it case by case.
I did. It's not on the agenda, so we
Right.
able to
Yeah, we
vote on it
certainly-
or make action. But
They can't vote on something like that.
correct. I can definitely make notes so that we can do that for the next meeting, although it'll be in September. However, I can remember 2 for sure that did request an extension due to the COVID-19 situation, which we reviewed on a case-by-case basis and allowed them an additional 6 months for those applicants.
Okay.
Can we just check though, if you want to make a special consideration, it is agendized as happening in this agenda item, but I want to confirm that with Ken. Would we be able to do that, Ken? This appears on the agenda, and it would be a response to a set of applicants within this item. Is it feasible to make that consideration here?
Let me take a quick look here.
I guess I'm thinking that we don't have to explicitly make that, if agendize that explicitly, if this is just in response to the current situation within this topic.
Yeah, I agree with you, Amy. I think that it's within what's covered there, and I think that would be appropriate.
Okay. So, Avidelio, if you wanted to make that,
Yeah, I mean, in general, I mean, I haven't thought about. I mean, if we were going to have a vote on a specific, we would obviously have to have like a specific time frame that we're thinking of to extend. Like if they have until April 2021, right now, I mean, we would think, what, do we want to go 3 months out from that? Do we want to go further? Frankly, I mean, I don't know. I mean, and this might also be like how many angels can dance on the head of a pin, because like if essentially if there's a fairly understanding sort of ad hoc extension policy, it could really kind of swallow up really anything that we're going to do right now anyway. But I would preliminarily, I would suggest if the deadline right now is April 2021 for everyone, I would at the very least suggest 3 months out from that. So end of July 2021, something like that. Or maybe even further. I don't know what other people think. Would anybody have an alternative date, like maybe further out, not as far out?
I'm good with your suggestion of July.
Yeah, I agree. I think at this point, a 3-month extension, if situations don't change or things happen that, extenuating circumstances come up with COVID and what's going on, we can always reevaluate and push it further.
Right.
I would agree with that as well.
Right. And it would, and frankly, just to save staff the time of having to, like go over each, kind of extension request, stuff like that. I just think it's probably best to do a blanket thing right now. So, okay. So yeah, let's see if we can take a vote. All those in favor of extending the current time frame for 2019 examination takers to apply from April 2021 to July 2021. What, do we have a specific date, or could we just say July 31st?
I would say we can just say the end of July. So
Yeah,
July.
July. Okay, end of July. So that would be what we'd have on the table.
That's the motion.
Extend it to July. So with that,
Roy, are you making that motion?
well, like, would somebody like to move?
I'll make the motion for you. It's Mark.
Mark moves.
I'll second.
Second.
There we go. Avi got in first. So boom. So there you go. We got his second. So
Okay. Are we ready to call roll
Yes.
for the vote? Okay. Hammerschmidt,
In favor.
Hersenson,
Aye.
Lester,
Aye.
Levy,
Aye.
Torre,
aye.
Vance.
Aye.
That's enough votes. The motion passes.
Okay. All right. So with that, I think we're done with that agenda item, and from there we'll move on to another item that Adrian will update us on, the certification of revocations for failure to recertify, where I think we're going to have a similar discussion. So Adrian, with that, update us.
Let's see. So item C is in regards to the approval of certification revocations for failure to recertify. Specialists are required to report compliance of the task and experience requirement and the reference requirement by recertifying every 5 years. Reminders are automatically sent through the Ames email system, and staff has also implemented a new 30-day late reminder through the state bar's email system. Through February 29, 57 specialists, 57 specialists are pending their recertification. Consistent with past action, staff will send a final notice via first-class mail and also electronically through the state bar's email system for them to submit their recertification or face revocation.
Okay, and now the action item here is to basically certify that these folks are revoked if they don't answer in 30 days. I would be voting against this. I think that I don't know about anyone else. Just and just for the very reasons we just talked about with the initial certs. I think that right now, although frankly, a lot of these people have gotten second, third, fourth warnings. We're in this environment. I'm very reluctant to cut off people's certifications. Maybe that's just me. Does anybody else want to chime in on that?
Yeah. At the last meeting, I took the list on the estate planning. I reached out to them, and much like my success factor back in January when we looked at this subject, virtually more than 75% of the folks were completely surprised that their designation was going to be terminated, and that was even before COVID hit. I'm not inclined to vote in favor of this motion at all.
And so I think now with the procedure, we would just because I don't think we have to take any alternative action here. I mean, if I'm getting my putting my parliamentarian hat on, I mean, if we don't, if we don't approve this, then they're not revoked.
Correct. So then their names would essentially be put on hold until the next CBLS meeting in September.
Okay. All right. So I would actually I would ask for a roll call vote on this, like those who would be in favor of revoking certification if no response to a final communication is received within 30 days, based on the the list we have here of people that are going to be revoked. It's attachment A to this agenda item. So, I mean, so we should take the vote.
I think we may still need a motion and a second.
Oh, okay, do I have a motion to take this, to take the vote as listed in the agenda materials?
Okay, I'll move to have the motion considered, so.
Second.
Perfect. Hammersmith,
Not in favor.
Hersonson,
No.
Lester,
No.
Levy,
No.
Torre,
No.
and Vance.
No.
All right, the motion is has not passed. Thank you.
And as an aside, I'm going to continue to reach out to every single one of these via email in the estate planning field. I just make that commitment.
Right, and also what we have to consider, and it's actually happened to me on a couple of just pieces of correspondence, not from the bar, but a lot of people aren't in their offices. A lot of people aren't, and a lot of people, I would actually say probably the vast majority of people are using their office addresses for any correspondence from the state bar or otherwise in their professional capacity. So a lot of folks are just either not going to be getting these things or getting these things much later than they typically get. Okay, so with that, I believe we'll move on to our next item. Again, another item for Adrian, as to the 2019 annual report of the Board of Legal Specialization. With that, we turn to Adrian.
Sure, thank you. So item D, this is review and approval of the 2019 annual report of the California Board of Legal Specialization. For some background, an annual report used to be sent to the Board of Trustees and the Supreme Court every year. In 2019, CBLS approved continuance of the annual report to still document historical data. So for 2019, this will be the 33rd annual report and would cover calendar year 2019. Notable, I guess, things to note that happened in 2019. The new admissions information management system launched in March. There was the sunset of the advisory commissions in May, and then we had the legal specialist examination in October. Did anyone have any questions regarding the annual report or any item in the report?
I was actually going to say, by the way, like, it's a really good kind of 11-page kind of nutshell of this whole thing. Is this report posted anywhere online for the public?
We can post it because it's also as part of the public agenda. It'll always remain there as well.
Okay.
But, we can definitely look for a place to post it, maybe on the legal specialization landing page or something.
I mean, it's like, because I don't know about everybody else. It's a really good kind of, in a nutshell, sort of recap of how the program works. So.
I've read that. I thought it was a great report. I'd love to see it posted somewhere that it gets some exposure and is tied in with the CBLS. It's impressive.
Right. Right. If all this work is going to go into something, like the body and the bar might as well take some credit for it. So, to have it hopefully coming, I think, shows people where the program's going. So, okay, now everybody's with that. We've been talking about the report. Has everybody had time to review the report and look that over?
Yes, I have.
Okay. Now, do I have a motion to approve the report?
I'll make the motion.
Second.
Second. All right, we'll have Adrian take the roll. Roll vote.
Hammersmith,
Aye.
Christensen,
Aye.
Lester,
Aye.
Levy,
Aye.
Torre,
Aye.
and Vance.
Aye.
That's enough votes. The report is approved.
Is approved. Now we're going to turn to the last item on open session, and I believe we're going to bring in an interested member of the public here. So with that, we would turn to the next agenda item, the discussing the IAPP, the International Association of Privacy Professionals, prior request, prior application for certification status, and a request for guidance clarification that we may consider today. So with that, I turn to Adrian.
Sure. Margaret, if you're on the call, could you please raise your hand just so I...
There we go. Hand raised.
All right, Margaret, I'll unmute you in just a second. Members, just as some background to remind you, the IAPP applied for accreditation in December of 2019. It was continued to February of this year to allow for more time for review. And at the February teleconference, the CBLS confirmed questions to submit to the IAPP for additional information. At the March meeting, the CBLS reviewed those responses, at which point the application was denied. So with that, I will open up, Margaret, your microphone.
Great, thanks, Adrian. Can everyone hear me?
Yes.
Excellent. Well, first off, thank you so much for including us on your agenda. I know that there's lots of business to get to. So, and Adrian just kind of summarized, why we're here. We received the letter of, not to recommend the IAPP as a new specialization in the privacy space. But at the same time, the letter did kind of keep the door open for us in terms of the ability to ask questions around how we might augment, what we're doing and our application to possibly be considered again. And I'm not sure how that process works. So, I appreciate just being able to talk with all of you today to gain a little bit of insight into the reasons for the not to recommend us. Clearly, it's stated in the letter, the two main areas, and I'll just toggle to that, which is that programs, approved by your entity should be devoted to serving consumer interests and have requirements that are comparable to the state bar requirements for board certification. And so Adrian and myself and two of my colleagues who are also involved in these programs at the IAPP had an initial discussion about what he thought was the reasons for the non-recommendation, and primarily the consumer-facing aspect of this, I think, is a big one. So I'd love to get a little bit more information about that. And then another area that Adrian shared with us was surrounding the MPRE, not wanting to accept that for the MPRE rather than sticking with the IAPP's ethics exam, which is part of the privacy law specialization. I really just would love to hear from all of you how we might be able to either change or augment what we do, because for full disclosure, we're willing to do what we need to do in order to try to improve our chances to work with all of you and possibly have privacy approved as a specialization. So, we obviously have, we're dedicated to the space. We have a clear vested interest in this. And we think, with the advent and the approval of CCPA and now CCRA in the works, there will be an increased need for lawyers to have this specialization. So I guess I'll just stop there and maybe open it up.
Hi, Margaret. This
hi.
is Aurelio. Hi. First, thank you for being here. We like to discuss these things, and obviously, you folks looking at your application and looking at your response to the questions, everything like that. You folks have obviously poured a lot of time into this, and you folks didn't just kind of it's a very impressive organization, and your application, frankly, was it had a lot of very interesting information in it. One of the things that I think we discussed, and it's something that leaves us a bit uneasy, is that this is a legal specialist certification that requires no additional testing than the non-lawyers that have been certified with the CIPP exam or the CIPM exam or the CIPT exam would have to do. And that's, that's a bit, now I'll grant, like looking at like the book of knowledge like that you had, like the CIPP exam has a lot of just legal, just a lot of like kind of regulation that, an applicant would have to know to pass that exam, which is true. But I think I and a lot of the other members of the board kind of had an issue. I was trying to think of the best sort of analogy here, and I came up with the analogy of like a contractor that's building a house. Like a contractor that's building a house is, has to follow a lot of building codes, has to follow a lot of different things, but he's not doing legal work, right? Mm-hmm. And what I wonder is that, like, how much of this is are people involved in the, the very process of dotting the I's and crossing the T's for people's privacy policies, for the implementation of like their privacy structure, as opposed to like actual legal practice. And we don't have an exam to like kind of separate those two things. The most they would ever have to take, if they didn't want to take the MPRE, which I would imagine is the easier way of doing it, is a 15-question privacy law ethics exam. That's multiple choice, and I have a couple other like things too. I mean, like the exam has no essay component, as I recall. Like none of the exams have an essay component, which is different from what we typically expect from what we have for the in-house exams that we have for the California certifications. So anyway, I'm sorry, I threw a lot out there.
No, this is helpful. And Adrian, I'm not sure, I have Rita Hymas, who's our general counsel, and she is really she's the one who spearheaded our initial development of this program. And she, kind of led us through the process when we did get accredited with the American Bar Association. And would she be able to be unmuted as well in order to provide some insight?
Yes.
Is that possible? Okay.
There it is.
Okay, I just wanted to have her on the ready because, I rely on her quite frankly heavily in terms of the legal aspect of all of this process. So I understand what you're saying. So that's interesting. So can you just to go back to your comment about your other specializations, are those outsourced as well? I guess is a question for me.
No. Well, some are. So
okay.
There are certifications from national groups that are recognized, just like you folks are applying for that.
Okay.
That have received basically kind of the reciprocity. I don't know exactly the term we're using, but one of my concerns was that it's a purely multiple choice exam. It's not there's no essay long form answer component to it where like you're applying a lot of facts, that sort of thing that we expect in, I believe, all of our California certification, California specialties.
Okay.
And also but the first point is that there is no differentiation in the examination process between a lawyer and a non.
Right. And the fact that we have the, proof of, time spent in privacy as well as peer reviews, that doesn't weigh any more heavily in that space.
I think it does. I mean, okay. This isn't. I don't think. I want to kind of clear up. I don't think it's all one-way traffic. Like in terms of like, there are obviously things that you have attorney recommendations, right, which is a standard part of our program.
Okay.
Like practice area. The other thing that kind of jumped out at me, you only require 3 years of practice, and our program is the bare minimum that somebody can be practicing to be a certified specialist in one of our specialty areas is 5 years.
And so I'll just jump in on that. And that's exactly why we wanted to have these conversations, because, you know, we're more than open to developing a program that fits, you know, your needs and your requirements. You know, I think Rita could jump in anytime to kind of reinforce the fact that, you know, we have those recommendations in place, but we have made exceptions for other states as well. I recently went through this with the Texas Board of Legal Specialization as well, and they also have the 5-year requirement. And so, you know, we definitely are willing and able to make those changes for states that require specific things.
How would that, theoretically, how would that work? So you would have people certify with you, but then they would have to be, there would be like a second, like an addendum to their application. Now, like if you would like reciprocity in California, you also have to meet these requirements. I mean, I don't.
Absolutely, yeah. So our intent is that we would have these specific state-specific requirements clearly illustrated on our website. And we have a whole certification team that works with individuals to ensure that they understand, you know, if you're looking to become certified or to become specialized in California, these are the requirements.
Well, and besides the tie-in from, you know, differentiating between non-lawyers and lawyers for the legal aspect of it, the other piece that we are charged with in taking a look at new specializations is that we are protecting the public.
Right.
We need to tie the requirements here into how is the public going to be benefited by recognizing these attorneys as legal specialists. How's the consumer going to be protected better from this legal specialization?
So I don't know, Rita, would you mind possibly addressing
I'd be happy to jump in, and I first of all apologize that I could not get on the call until just a few minutes ago, so I may have missed all sorts of really great stuff, and I try not to make you go backward and ask questions, but from what I've just heard in the last few minutes, I want to echo what Margaret said about our ability to differentiate from the position of the applicant for IAPP's specialist designation, depending on which state they're applying from. So if someone applies to be an IAPP designated privacy law specialist as approved by the California bar, then we obviously would require them to meet the standards that you have placed on us. And that administrative piece is not at all complicated from us, because we take every application in one at a time, and they're handled by lots of people, you know, to make sure that someone meets the standards. So we can easily build our sort of subjective, some of our objective criteria in terms of number of years of practice, and even what is required to be considered, using ABA's language, the substantial involvement in the practice of privacy law. Those sorts of issues that are unique to each applicant and require them to explain in their application the number of years of law practice and the type of law practice, that we can easily tailor to each individual state and their requirements. It is admittedly harder for us to go back and change our tests. So that piece, I think, is the one that we maybe should talk about a little bit more. Our exams have been accredited by ANSI. They meet ISO standards, so they have met an international level of accreditation standards, and we're not really going to go change those tests because they work so well the way they are. But it is a different question for us to create an exam that is specific to the California bar, that meets the needs of your bar. And so it might be helpful to us to understand what that looks like, and if there's room for there to be more than one component, our exam plus an exam that is tailored to your requirements. Setting aside the ethics exam for the moment, just one that is substantively tailored to your needs. Was that responsive at all to the questions that are on the table?
Yes. And,
okay,
thank you. That's actually like that's one of the main things for us. But even though Mark pointed out correctly that there's like a meta issue like that we have to talk about before these specifics. But as to these specifics of the exam, there are certified, for instance, like I practice a lot of child welfare law. There's for instance, there's a National Association of Child Welfare Law that gives a juvenile law specialty where the law tested is not necessarily California specific. In fact, most of it isn't California specific, but it's still a legal exam in the sense that there's a lot of application. There's an application of the law and like long form kind of analysis required as part of the exam that is specifically legal, like the kind of legal advice one would be giving to. And here, I mean, and again, like I said, the CIPP/US exam, that one, like a lot of the stuff in like the knowledge book that you provided is knowledge of a lot of these regulatory things. But what in the end, it's hard for me to kind of get my head around giving a legal specialization where the exam itself and actually some of the practice things are not necessarily things that only lawyers do. Like I was looking also at the substantial involvement stuff, some of these things, routinely preparing privacy notices, drafting and reviewing vendor agreements in compliance with privacy security laws, conducting privacy impact assessments. Those are things that lawyers can do. You could obviously correct me if I'm wrong. Those don't seem like things that are strictly legal. And those are things that you include in the substantial involvement that somebody could say, I do all of these things, so I'm a privacy law, I should qualify for the again, I'm rambling. I put a lot about
No, I fully follow all of you. And I think if I may, there's no question that the American Bar Association also had a bit of a struggle. The funny thing is, when we first started with them, I think it was they just weren't quite familiar with the fact that privacy law has so rapidly become a thing. I don't think that's in doubt anymore.
Right.
And one of the things that is useful to the IEPP being able to fill this specialization role is that we have been doing this for 20 years now. And so we can get there quickly, whereas anyone who's starting now, it's going to take them a while to build a specialization program. Assuming that, now that the CCPA is in effect, and soon we'll have class action suits, we already do, you want to get up and running quickly and avoid consumers hiring someone who doesn't know what they're doing, then we can get there quickly if we use what we've already built. So there's some expedience to what exists. Now, that expedience isn't always the answer, and I get that. And I think one of the instincts that I have is that our field has been principally dominated by practitioners that are doing more transactional style work, a lot of international legal compliance work because the field itself is necessarily global, a lot of counseling on compliance. And so that's more likely to be the applicant for our specialization than someone who's litigating. But as a lawyer and someone who runs our privacy bar section, it's clear to me that the new crop is going to be lawyers. We are going to have more defense counsel. We're going to have more plaintiffs counsel. And therefore, it will become more of a consumer facing specialization than it used to be. It used to be a lot of in-house positions and companies that were hiring outside counsel in big law firms with big law practices. And I definitely see this becoming something where consumers are going to be looking for an attorney to represent them. So I'm not disagreeing with you at all. I think we are facing a new crop of privacy lawyers, and I guess my defense of the IAPP is really just that we're in the market already. We're incredibly well established in this space, and so if you want to get to market quickly, we can satisfy that. But that may not be your aim, and if that's not your aim, then let's talk about whether we can provide the kind of credentialing that you need.
So Rita, along those lines, we specifically asked the question, who are the clients of these lawyers who would be part of the privacy specialty? And the response we got was really a non-answer, that we don't ask who the clients are. And so, from our perspective, we don't know who the clients are, who these specialists are.
Yeah. Mm-hmm.
We're looking at, primarily, as you said, historically, we're looking at corporate lawyers, and that doesn't really satisfy our goals or our aims. And so in order to make the specialty relevant to the state bar, there has to be a strong consumer. And we just haven't seen anything along those lines. And whether it's changing or not, you know, that's something that would have to be demonstrated before we consider.
So I just have my question for you is, and I completely respect and appreciate that, and that's why child advocacy, juvenile justice, even OUI defense and bankruptcy often are aimed at individuals, small businesses, as opposed to corporate compliance and multinational company compliance. Like that has not, in my impression, from what I've studied of the other areas of specialization, those areas have not tended to be places where lawyers bothered to seek specialization. My instinct is that this has become important to the attorneys because they want to make sure that they're recognized for their years of practice. In terms of the consumer demand, I think it's coming. I'm not sure it's here yet, because this has not been an area where people have been able to personally seek relief on their own behalf. They certainly haven't been sued personally or accused personally of violating privacy law. So they are just now, in part because of California, starting to have access to rights that they have never had before. And if we are ever to have a US privacy law, they'll have them across the country. It's just budding as a consumer protection issue, to be honest. Prior to now, people have had to rely on whatever common law claims they could get a lawyer to creatively make on their behalf. So it's new to have a statutory right, a statutory consumer right. So here we are. We're at the beginning from a California perspective, but with an IEPP regime that's been built for a long time. And is there a way to meet in the middle? And is there a way for us to meet what you're looking for?
Well, I think like I want to just take off what Natalie said, because I think that's the main point Mark made it before, that we almost have, we wouldn't want to put, and I understand everything you just like said, I can sympathize with it, but we would kind of be putting the cart before the horse. We're right now, like our program is focused like a laser beam on public protection. And like, do we have like all of these certifications? Like, is this a fundamental, the fundamental purpose here is to protect the public. And what you're saying, and I appreciate your candor, because I don't think that the market for like the general public, as opposed to kind of like larger entities, maybe like in the corporate counsel sort of, sort of realm, is necessarily there. And maybe this is a conversation that looks foolish in 5 years. Maybe like by then, like, like the market for, for small businesses and for individuals in this space is such that the public protection element is manifest, just completely clear. What I think Mark is saying, Natalie's saying, and what I'm in a very long-winded way saying is that I don't think we're necessarily there. We don't have that, that proof here yet. And that's not, again, that's not something that, I mean, that's in addition to some of the technical stuff we talked about the exam and about that, but like the fundamental thing has to be like, is this something where we have to step in as a board? Because there's a crucial public protection element here. And I don't necessarily see it. I don't foreclose the possibility of it becoming clearer, but I just don't see it here.
Yeah, I mean, it wouldn't be smart of me to argue with you. It certainly wouldn't be a very good idea to say that you'll be foolish at any point. I personally am quite convinced that this is a need that will be present within the next couple of years. The legal community, the legal legislative motions are already off and running. Obviously, California is way ahead of the game, and potentially even having another amendment to the CCPA this fall. So yes, it's going to be there. If it isn't there already, it will be there within the next 24 months. I think 5 years is way too far in the future. Really. Now,
do we have, do you have, you said you don't really ask, like Natalie was pointing out, you don't really ask like what the practice focus is. Would there be a possibility of doing so? So that we could get some sure. Some kind of like data as to how much of a public protection you know, how our public protection goal will be served by having you folks in as one of the bodies that we recognize.
Absolutely. And I think the comment is that we're maybe not asking who your clients are, but we certainly have to ask for our ABA accredited and other state specializations for a pretty detailed description of their law practice. So yes, we know the kinds of law that they practice and the kinds of tasks that they undertake. We have to in order to see if they meet our standards. So, but in terms of getting statistics and data on what kinds of legal matters, including litigation and other consumer protection facing things, that's something we could go gather. Absolutely. Yep.
Okay. Okay. Now, anybody else want to chime in on it?
I have one question, and I apologize if this was kind of addressed before, but obviously we've got CCPA, and then different states have different legislation and different practices in place, and GDPR overseas. How do you differentiate, or do you differentiate between where the practice areas are for the people that are applying, and how do you address the individual specific laws and legislation in those areas, so that we're charged with public protection for specifically in California, right, which is different and you've been addressing, but so do you differentiate between the location of the applicant and the practice area?
Not necessarily, Rob, because the American Bar Association accreditation is recognized in almost over half of the U.S. states, so it's not necessary to tailor their particular jurisdiction to the specialization that we provide. But as Margaret pointed out earlier, we can, because we realize we aren't under the ABA. Our lawyers from California don't get to take advantage of that. If they want to be deemed specialists and the IAPP is the accrediting body, well, then we need your permission to do so, because you're not recognizing the ABA's specialization, which means here we are, right? Trying to figure out what it is that you need that we might be able to build to meet your standards. Right. And again, just to go back, we definitely had a couple of years back and forth with the ABA, because it wasn't always clear what they were looking for. And I don't even know if they always knew. And so the dialogue really helped us to make it so that what we had met their standards. It took some time, and it was very helpful and very constructive time. So no regrets there. But yes, we would build what is needed to meet your standards if we ourselves can better appreciate what they are.
Sure.
And absolutely require applicants from California to be explicit if that's what's needed.
Thank you.
Just curious, why is the ethics exam, the privacy law ethics exam, the one that you give, and theoretically the only like legal specific exam, why is that only 15 questions?
Excellent question. I'm sure our psychometrician had a reason for that. Probably it was a, I know I helped put the thing together, so I'm stumbling as to what, going back in time, why it was that length. I assume it was because that was the amount of percentage required relative to the other exams. It could certainly be longer. Our process, by the way, for creating that exam was to study the MPRE's style of questioning, to convene attorneys from a variety of different practice areas, inside counsel, outside counsel, healthcare, regular litigation, blah, 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 and ask them to put forward the kinds of professional responsibility questions that they actually come across every single day in their practice. And then we wrote questions with our trained exam writers to meet, and then we tested it. We tested it with a bunch of law students. We had studied for the MPRE, and we've had great success with it in the field. We get exactly the kinds of results that we would expect. But it could be longer, and again, we could also issue a different California-specific ethics exam. That piece of it, I don't have any problem working on, and it may be the place to build in the essay questions as well.
That's a really good, and that's a really detailed answer, and like it makes sense as to the development of the test, which kind of brings up the question to me: why isn't it required? Like you have this specific like ethics exam that like a lot of work goes into to develop, and with your psychometricians and stuff. You say you got to take this, or just give me an MPRE score where I mean that frankly the MPRE is not the most demanding of tests, and so I don't know why don't you just require this exam?
Yeah, as a practical matter, Aurelio, everyone takes our ethics exam because by the time you've had the kind of practice experience to qualify for you, almost everyone is well away from their MPRE days. I took mine in the early 90s. I don't know about
It would
you.
make, look, it would make me a lot more
Yeah.
comfortable
Yeah.
if it's just, that's the MPRE just isn't a ticket in.
And we heard you, and that is not a, that would not be, it is a ticket in because we don't have California's approval yet, but for California lawyers, when we win your blessing, that will not be an option for them. And maybe your advice will drop it for everybody. That's an interesting suggestion. I had not heard anyone slam the MPRE before quite like that. So
I'm not slamming.
Thank you for bringing that.
Whoa, I don't want to have any
Just
people
kidding.
come after me.
All right,
But, like,
terrific.
it's one of those things. If all this time is going to go into like a privacy law specific ethics exam, or you can take this generic ethics exam that everyone takes like during law school.
That's a great point.
That's
a great point.
I don't know. So.
And may I also add just one more quick thing? I'm sorry, Natalie. Go ahead.
Oh, I was just going to add that, you know, from our perspective, we are certifying specialists in a practice area that distinguish them from other lawyers. And everyone has to take the MPRE to become a lawyer in California. That does not make them a specialist in anything. So, you know, that's why it just doesn't work.
It makes good sense, actually. The only other comment I was going to make is that we have a committee of attorneys, privacy attorneys, who help us on a volunteer basis evaluate our applications. So this is actually not an entirely in-house decision. Members of our privacy bar section who are on the advisory board volunteer to review applications, and we could certainly build that kind of a board that was made up exclusively of California practitioners. It's one of the best ways that we function is because we are a membership association, just like the ABA or just like in the California Legal Association. We rely on our members who are really on the ground every day to help us build our exams like this and to help us evaluate people for their specialization criteria. And they're tough. They do not say yes unless they really are convinced that people are qualified.
Okay. By the way, you have an estimate that 40% of your members are lawyers. What percentage of CIPP certified folks are lawyers? Because there's a difference, right? Yeah, like I could become a member tomorrow, right? Just sending in like the.
Correct. That's correct. Yep. I don't know. Actually, I don't know. We have practiced data minimization to the extent that it should be envied of any company and any regulator on the planet. So we actually have very little specific data about each of our members. We know their name and their email address. And as we grow as a company, we are learning a bit more, but these are literally things we haven't tracked. We just don't.
Clearly as a matter of privacy. Yeah.
It's true. It's painful for our data analysts, but yeah.
Okay. Anybody else have any questions, concerns they want to voice?
No, I appreciate you taking the time. It's again, it's the more we learn about you, I'm impressed with the organization.
Yeah, likewise. And I think that, you know, I think I may speak for several members when I say that it's not for necessarily kind of like judging the standards of the organization as much as it is that we have been, especially in recent years, like we have been even more kind of focusing like with a laser beam on this public protection purpose. And there seems to be a little bit of fog of war as to how much of that we'd be serving here with your organization. And that's the thing. And these are, it's like denying a motion in court. It's like I think these applications are perpetually denied without prejudice. You know, if there was information that came to us about that, then obviously we would reevaluate.
Well, we really appreciate the time that you've taken to study our materials, to think very seriously about our application, even if you're denying it without prejudice, I hope. This is how we learn. It is iterative. We figure out what it is that you're looking for, and we try to build something that is right for you and that is right for your the citizens of California, the consumers. So we'll go back and huddle and see if we can answer your concerns.
Yeah, so Rita, this is Margaret. I got unmuted, so I'm able to jump in now. To Rita's point, we'll go back with all this information. We greatly appreciate it. And I just want to be clear about possible next steps. Do we just stay in touch with Adrian in terms of, how we might be able to move down this path?
Yes, like that. That would be again. I mean, Adrian is the point person for these kind of things, as he has been.
Right.
And again, like obviously you've seen, like we've gone over this stuff. Everybody's kind of and I think I speak for everybody. We're like we have there's a lot of impressive elements to this, and we're not shutting the door forever. We're just saying, I mean, not quite
Right.
yet. I just don't think we have enough information.
No, and we greatly appreciate that. And this was so helpful for us. And Rita, thank you so much for providing all the background information as well. Clearly very valuable for everyone to hear. So thank you. Thank you so much. And we'll be circling back then, Adrian.
Thank you. Thank you very much. Really appreciate it.
Thank you.
Thanks, Margaret.
Thank you.
Thank you, Rita.
All right. So with that, that's the final item on our open session. So we'll be moving to closed session. I believe Adrian's recently sent a link. We can go to that, but let's take a quick break. What? It's 11:30. Would 11:40 work for people?
Perfect.
10 minutes?
Yes, that works.
Minutes
More
would be
coffee, all
very
that stuff.
helpful. Thank you.
Cool. All right. See you folks at 11:40.
Thank you.
Thank you.
And recording.
Okay, we are back in open session after the closed session of the June 5th. That's right. That's what today is. CBLS meeting. So we're in open session. I would announce the end of our session. Both open and closed items have been taken care of. Thank you for everybody for attending, and the meeting's adjourned.
Thank you.
All right. Thanks, Adrian.
Thank you. No problem.
Thanks, everyone. Have a good one.
Thanks. All right. Have a good one. If you have any questions or anything that you want to ask me, like, or email